Pranam, Namaskar, Jai Shri Ram. Welcome back to the second episode on Waqf Amendment Bill 2024 and recommendations as given by Joint Parliamentary Committee on the same topic. Previously, we had stopped up to recommendations given up to clause 8. We now move further. Clause 9. The committee, after thorough deliberation upon the proposals made in the clause under examination, including the views, suggestions of the stakeholders, and the justification given by the Ministry of Minority Affairs, find that considering the statutory nature of Central Waqf Council, inclusion of 2 non-Muslim members will make it more broad-based and promote inclusivity and diversity in Waqf management. The bill has further emphasized upon the participation of Muslim women in the council. Hence, the committee accepts all the amendments proposed under the clause. However, it has been brought to the knowledge of the committee that the presence of non-Muslim ex officio members may result in fulfilling the requirement of the proposed amendment, whereas this may go against the intent of the proposed amendments. Hence, the following amendment is proposed in second proviso of clause 9. Provided further that 2 members appointed under this subsection, excluding ex officio members, shall be non-Muslims. Clause 10. The committee, after thorough deliberation upon the proposals made in the clause under examination, including the views, suggestions of stakeholders, and the replies given by the Ministry of Minority Affairs, find that separate boards for Bohra and Aga Khani communities will give them the necessary independence needed for managing the affairs of the respective community as per their distinct religious doctrines and practices. The amendment thus accepted. This is a major breakthrough where the Bohra and Aga Khani communities are now getting properly represented and not coming under the same Waqf board or Waqf council. Further, the committee agree with the submissions made by the Dawoodi, Bohra and Aga Khani communities, which although are parts of the larger Shia Muslim community, have a distinct set of religious doctrines and practices. As a minority within the Shia community, the Dawoodi Bohras follow a unique governance system that revolves around the religious authority of the Al-Dai al-Mutlaq. In this respect, the Ministry have suggested for amendments in Section 2 of the Principal Act by providing that this Act shall not apply to a trust established by a Muslim under any law for the time being in force. Consequently, the committee recommended that the following proviso may be inserted in Section 2 of the Principal Act. Provided further that nothing in this Act shall, notwithstanding any judgment, decree or order of any court, apply to a trust by whatever name called, established before or after the commencement of this Act, or statutorily regulated by any statutory provision pertaining to public charities by a Muslim for purposes similar to a Waqf under any law for the time being in force. Clause 11. The committee, after thorough deliberation upon the proposals made in the clause under examination, including views, suggestions of stakeholders and the justification given by Ministry of Minority Affairs, find that the composition of state Waqf boards has been expanded to include 2 non-Muslim members and ensure broader representation from Shia, Sunni and backward Muslim communities, which will promote inclusivity and diversity in Waqf property management. Here the word backward Muslim communities is important. Most of you must be knowing by the name Pasmanda community. The committee feel that non-Muslims can be beneficiaries, parties to dispute or otherwise interested in Waqf matters, which justifies their inclusion in the administration of Waqf. And the committee accepts the amendments proposed under the clause. However, it has been brought to the knowledge of the committee that the presence of non-Muslim ex officio members may result in fulfilling the requirement of the proposed amendments, whereas this may go against the intent of the proposed amendments. Hence, the following amendments are proposed in clause 11. The proposed subsection 1E of subsection 14 be substituted as given. Joint Secretary of the State Government dealing with Waqf matters, member ex officio. The second proviso to subsection 1 of section 14 be amended as given. Provided further that 2 members of the board appointed under this subsection excluding ex officio members shall be non-Muslims. Clause 12. The committee, after thorough deliberation upon the proposals made in the clause under examination, including the views, suggestions of the stakeholders and the justification given by the Ministry of Minority Affairs, find that this clause would ensure that individuals with a clean legal record can serve on the board, improving accountability and trust. Hence, the committee accept the amendments proposed under the clause. Further, the committee are of the opinion that the condition for disqualification given in section 16A, that is, he is not a Muslim and is less than 21 years of age, is incongruous with other clauses provided in the bill. Therefore, the committee recommends that for clause A, the following clause shall be substituted, namely, he is less than 21 years of age. After clause A, the following clause AA shall be inserted. In case a member under clause C of subsection 1 of section 14 is not a Muslim. Clause 13. The committee, after thorough deliberation upon proposals made in clause under examination, including views, suggestions of stakeholders and justification given by Ministry of Minority Affairs, find that regular monthly meetings of the board are required to ensure continuous oversight and faster decision making on Waqf property matters. Hence, the committee accepts the amendments proposed under the clause. Clause 14. It is found that section 20A, which allows the removal of the chairperson by a vote of no confidence, has been removed because the chairperson will now be appointed on a nomination basis and his removal will be governed by section 20. Hence, the committee accepts amendment proposed under clause 15. It is found that the position of Chief Executive Officer CEO is now open to individuals from all the communities, which would promote diversity and professional management. Further, the CEO must be at least at the rank of Joint Secretary to the state government, which would help ensure better coordination among various concerned departments of the government. Hence, the committee accepts the amendment proposed. Clause 16. It is found that explanation and proviso to section 32(2)(e) concerning board powers being exercised by Sunni or Shia members only. Viewers, please read this carefully. Board powers being exercised by Sunni or Shia members only are being omitted to align it with the proposed third and fourth proviso to section 14(1) and removal of section 13(2)(a). Further, finality of decisions of the tribunal on the matters related to settlement of schemes of management for a Waqf under section 32(2)(d) and utilization of surplus income under section 32(2)(e) has been omitted in order to allow appeals to the High Court within 90 days from the tribunal's order, which will expand the scope of judicial remedies, ensuring that aggrieved parties have access to broader legal avenues for resolving legal disputes. Hence, the committee accepts the amendments proposed under clause 17. It is found that the proposed amendments remove restriction on the power of the tribunal to stay the CEO's order, allowing for judicial scrutiny to prevent miscarriages of justice. Further, section 33(6) is omitted, which means decisions of the tribunal are no longer final. I am repeating, it means decisions of the tribunal are no longer final and parties can appeal to High Court, which will expand the scope of judicial remedies, ensuring that aggrieved parties have access to broader legal avenues for resolving legal disputes. Hence, the committee accepts the amendments proposed under the clause. For viewers who are unaware, tribunals have become so draconian and totalitarian that the decisions given by them were not even challengeable in the High Court, and that has now been removed under this recommendation. Clause 18. it is found that execution of Waqf deed for the new Waqf would strengthen the legal status of such Waqf and reduce the number of litigations owing to the absence of written documents related to a Waqf property in the future. The measures introduced to inquire into the genuineness and validity of a Waqf would further reduce disputes and claims on grounds of wrongful declaration of Waqf. And the amendment is accepted as it is. However, the committee, while examining the proposed subsection 10 of section 36, which states that no suit, appeal or other legal proceedings for the enforcement of any right on behalf of any Waqf which have not been registered in accordance with the provisions of this Act shall be instituted by any court after the expiry of a period of 6 months from the commencement of Waqf Amendment Act 2024 feel that the time period may be increased to give adequate time to all stakeholders to represent. Therefore, the committee after deliberation recommend that instituting of suit shall be allowed beyond the period of 6 months, and accordingly the following proviso to subsection 10 of section 36 be inserted. Provided that an application may be entertained by the court in respect of such suit, appeal or other legal proceedings after the period of 6 months specified under this subsection, if the applicant satisfies the court that he has sufficient cause for not making the application within such period. Clause 19. Clause 19. After careful consideration of submissions of various stakeholders and replies received, they are of the opinion that the proposed amendment for central government's prescribed particulars for register of Waqf shall ensure consistent record keeping across all the states. Further, public notice in local newspaper provisions for land record mutations as per revenue laws ensures the right to be heard, transparency and accountability, and the protection of individual rights. This step will also allow rightful property owners and stakeholders to raise objections or provide evidence, upholding the principles of natural justice and preventing wrongful classification. It also aims to provide opportunity to affected parties to be informed and heard before any changes are made to land records involving Waqf properties. Hence, the amendment is accepted as it is. Clause 20. The committee, after thorough deliberation with various stakeholders and considering the replies received, are of the view that omission of section 40 of the Principal Act will be essential to rationalize the powers of the board to ensure that Waqf are declared after following due process as per provisions of the Act. This is an important amendment, so it is accepted as it is. Clause 21. The committee are of the opinion that the change of deadline for submitting Waqf accounts from July to October shall allow more times for accurate reporting. Further, Mutawalli will prepare true statement of accounts of Waqf in such form and manner and containing such particulars as may be prescribed by the central government of all monies received from any source, which will help in ensuring transparency in the financial management of Waqf. Hence, amendment accepted as it is. Clause 22. It is of the combined view that this amendment seeks to ensure that Waqf properties with significant incomes are audited to improve accountability. Moreover, it will also make Mutawallis more accountable. Remember, till date, many of the properties income expenditure statements are not audited. Further, the committee noted that earlier there was no such provision for publishing audit report. With this amendment, better transparency will be there in monitoring audit report. Hence, amendment is accepted. Clause 23. Stakeholders are of the opinion, including Ministry of Minority Affairs, that through the inclusion of subsection 48(2)(a) wide clause 23 of the bill, the method of publishing the proceeding and orders of the board passed on auditor's report will now be prescribed by the central government. The committee are of the opinion that this will ensure transparency and public access to important information. Committee further noted that the tribunal shall now be permitted to stay the board's orders on the matters related to auditor's report when necessary for appropriate judicial scrutiny and mitigating miscarriage of justice. The finality of the tribunal's decision on the order passed by the board on audit reports of the Waqf has been removed, allowing appeals to the High Court within a specified period of 90 days, which will expand the scope of judicial remedies, allowing for further appeals and ensuring that aggrieved parties have access to broader legal avenues for resolving legal disputes. Hence, amendment is accepted as it is. Clause 24. Committee stakeholders and ministry are of the view that only individuals of good character can become muttawalis, that is managers, and holds them accountable for their actions. Hence, amendment accepted as it is. Clause 25. Combined opinion that removal of the finality of the tribunal's decision shall allow appeals to the High Court within a specified period of 90 days. This will expand scope of judicial remedies, allowing for further appeals and ensuring aggrieved parties have access to broader legal avenues for resolving legal disputes. Hence, amendment is accepted as it is. Clause 26. The view is that the amendments to Clause 26 of the bill seek to make the provisions in consonance with Section 52A3. Further, the committee are of the opinion that Section 52A2 and 4 are being omitted to make alienation of Waqf property, as mentioned in Section 51, liable to a judicial trial before any judicial magistrate dealing with the cases having provision of imprisonment for a term which may extend to 2 years. Hence, amendment is accepted as it is. Clause 27. Committee, stakeholders and ministry are of the view that, particularly keeping in view the introduction of appeal to High Court against the order of tribunal, decided to accept the amendment proposed under Clause 28. It is found that the role played by the muttawalis in the administration of Waqf property is extremely important and instrumental in achieving the pious, religious and charitable goal as envisaged under the auspices of Waqf. In this context, the committee feels that greater accountability and transparency in the functioning of muttawalis certainly need to be ensured through stringent and deterrent measures. Hence, decided to accept the amendment proposed under the clause. Clause 29. The committee take into account the fact that improper maintenance of accounts of Waqf property is one of the primary reasons for the deep-rooted administrative malaise afflicting the management of Waqf properties. In order to streamline the accounting pattern of Waqf properties, it is of utmost importance that timelines be adhered to scrupulously and any violation be dealt with strictly. In accordance with such requirement, the reduction in deadline for the preparation and updation of all accounts of Waqf properties is the need of hour, which would delegate greater responsibility on muttawalis and usher in much needed professionalism in the management of Waqf affairs. Moreover, it is only in the fitness of things if any person having any connection with illegal activities be barred from discharging a pious duty of muttawali. Therefore, the committee accepts the amendment proposed under the clause. Clause 30. After going through the proposed amendment, wide Clause 13, Section 65, subsection 3, find that giving a fixed time period for filing of reports by Waqf boards to the concerned state government is a move in the right direction. Fixing 6 months after the close of every financial year rather than keeping it open-ended through as soon as possible gives a definite time frame for ensuring accountability in management of affairs of Waqf boards. Hence, committee decide to accept the amendment. Clause 31. Committee finds that Section 67, subsection 4 is being proposed to be substituted with the first provision of the Section 67 of Principal Act wide Clause 31 of the Amendment Bill. Thereafter, in the second provision of Section 67, subsection 6, the omission of the words "and the order made by the tribunal in such appeal shall be final" shall be omitted. So, final powers of tribunal have been removed and it is now left for disputants to approach higher courts and further courts. These amendments are aimed at providing any person aggrieved by the order made by the board under Section 67(2) chance to appeal and utilize the various avenues of appeal for justice. Thus, the committee appreciated the option of providing further scope for availing justice to the aggrieved person and decided to accept the amendment proposed under the clause. However, the committee recommends that the period of appeal shall be increased from 60 days to 90 days and accordingly propose following amendment in clause 31A. Any person aggrieved by the order made under subsection 2 may within 90 days from the date of the order appeal to the tribunal. Clause 32. Committee note that clause 32 of the bill seeks to amend section 69(4) by adding a proviso which incorporates that no order shall be made under this subsection unless a written notice inviting objections from the person likely to be affected and general public is issued. The committee concur with the intent of the amendment regarding principles of natural justice and right to be heard and therefore accept the amendment as it is. Viewers, will take a pause here in the second episode. There are many other clauses which have gone into amendment, which I will be putting up in the next third video in this long series of Waqf Amendment Bill report. So, till then, stay tuned, stay connected. Thank you all for watching this video. If you like this video, please press the like button, subscribe to my channel and also share in your network. Don't forget to press the bell icon so that you continue to receive updates on all videos posted. Till then, thank you, Pranam, Jai Shri Ram.